Danielle, please. And Brent, your motion.
Thank you, Your Honor. Good morning. May it please the court and counsel. We would ask that the court look at all the factors and use its discretion to stay the proceedings, stay the suspension that the school has imposed on Mr. Barber. This legal issue does raise a lot of questions before the court, all of which I believe can be answered in Mr. Barber's favor. The Attorney General, Your Honor, has, of course, questioned Mr. Barber's ability to even raise these issues since they weren't raised in his appeal statement. But although the typical rule is you can't raise new issues in a court that weren't raised before the board, that doesn't apply here because of the limited authority that the school appeals board has under the law. There's some analogy made by the Attorney General to these cases, in front of the Pollution Control Hearing Board or the Growth Board, Western Washington Growth Management Hearings Board. But those sort of entities have broader authority than the Appeals Board. Even the Growth Board or the Pollution Control Hearings Board, they have an attorney sitting on their board. That isn't true of the school board. And the Appeals Board for the school can only review certain things. They certainly can't review constitutional issues. And whether or not a person had his or her questions asked in a fair manner and discretion being used is certainly a constitutional question. I mean, if the Pollution Control Hearings Board and the Growth Board don't have the authority to, board the school to. So I think those cases are distinguishable. The other thing is, we hear right and left from the school and through their materials about how the process is supposed to be educational. On the record on page 75, one of the notices to Mr. Barber says the board does not follow the formal processes of a criminal or civil court. And yet the Attorney General would say, well, Mr. Barber here should have raised objections in Title 34. But if you look at all the notices, it says, okay, Mr. Barber, please familiarize yourself with the Code of Conduct under the WACs. There's nothing in the RCD or nothing in the materials that say, well, you need to preserve objections as a college student under the APA. So I don't understand how that standard, would really apply. And if you look closely at the record, you can see that what a student to do an appeal, what he or she does is they actually fill in a template. They go onto the website, type in their student ID number, and they fill out a template. And I think that's clear from the record that that's what did. So I think certainly Mr. Barber would have the right to, raise this issue now. Now, if you look at the, standards under the law for issuing a stay, there's a requirement of likelihood to prevail on the merits. Here, I did notice that the Attorney General essentially conceded that the school board, the conduct board, should have preserved the records, and they did not. It was also conceded that they did not. However, they say, well, Mr. Jussel can attest to the fact that all the questions were answered. But that, of course, directly conflicts with Mr. Huffman's recollection. But also, if you listen to the audio of the hearing, you can hear Dr. McIntyre paraphrase the questions. She's not reading those verbatim. You can hear and she's paraphrasing the questions. So I don't understand how that could really, how the school can really claim that all the questions were asked. And the opposing counsel says, well, here's her declaration, this simply didn't happen. But she's essentially saying that the court should have favored the WSU employee think that's right. That's where the prejudice lies. That's why we have records. That's why we have file stamps, and that's why we have things maintained, so that there's no quibbling about what exactly existed, here 7 weeks down the line. So that's what I'd ask the court to consider. Now, if you look at these other factors, irreparable injury that the petitioner might face, he's kind of at the last leg of the school here. He's just trying to get this done. He's in the middle of a semester. He's also can't give him back the season, you can't give him back the semester, you can't give him back his good name either. But the school can always, if they feel that they have prevailed in the end, the school can always, essentially revoke a degree. I've had cases where people have, been in the middle of the semester, allegedly committed misconduct, and then they've walked, gotten their degree, and then essentially had a suspension after the fact. And then 2 years later, after the suspension, they get a degree, and the only difference is it's got a different date on it. So that's what I would ask the court to consider. I think under the APA, you can see circumstances where there'd be some sort of harm to the public if there was a stay. I mean, obviously, if the Department of Health yanks the license of a doctor or physician, and then but I haven't seen any sort of danger to the public here of having Mr. Barber in school. And if you look at, this record, it's clear that the state, WSU, hasn't opposed the stay. The stay was what they did. When this was first alleged in July 23rd of 16, they didn't kick him out initially. They didn't, suspend him. They have the authority to do an interim suspension. They didn't exercise that authority. Then they sent him a letter in August 8th notifying him of the charges. Then they have a hearing on September 7th, and then they kick him out of school on September 13th. They don't kick him out, and they let him stay in. In effect, they had a stay. And then when it was pending appeal, the matter was stayed. Even when the appeals court rejected this, his suspension was on hold. And it wasn't until 10 days later, and then we get to court, they say, well, there shouldn't be a stay. There's a big danger to the public. But, the facts really undercut that. The other thing is, they make a lot of this issue that happened in the year or so prior, where he exchanged words with a man who ended up being an off-duty police officer. But they make a lot of that and say, well, this is a danger, to the public Mr. Barber poses. But if you look at that, by all accounts, he didn't lay a finger on anybody. And if that was so serious, why would the school just have him write a reflection paper as the punishment? So I don't understand how they could point to that and say he's a threat to public safety. And then the other thing is that if it's such a danger to public safety, he's expelled. But here they're saying, oh, he's this grave danger immediately, but we'll welcome him back with open arms a year from now after he's done a suspension. And that just doesn't really make any sense. So I would ask the court to look through this, balance out these factors, considered the actions of the school and stay this matter. I'd like to, if I could reserve just 2 minutes for rebuttal.
Morning, Your Honor. Hess here on behalf of the respondent, Washington State University. The basic facts of this case are undisputed. Mr. Barber was at a house party. The party was getting out of hand. The residents tried to get people to leave the party. Mr. Barber testified at his conduct board hearing that he felt someone push him from the side. He testified that he didn't know who the person was, but he felt threatened, and so he started punching. The student fell to the ground, and he was lying on his back, and Mr. Barber testified that he punched the student again while the student was lying on the ground. The student was unconscious and bleeding, and he was taken to the hospital where he was diagnosed with a concussion. This was not Mr. Barber's first conduct incident. His first incident was in 2015. He got upset because his friend was arrested. He hit the side of a car. He yelled racially charged comments at bystanders, and he threatened to, quote, beat the shit out of an off-duty police officer. The officer informed him that he was, in fact, an off-duty police officer. Mr. Barber threatened him again and said, quote, when these officers leave, I'm going to beat your ass. The officer tried to call 911. Mr. Barber threatened him again, called him a, quote, little bitch. The officer was able to contact other officers. Mr. Barber was arrested and cited with harassment, which is a gross misdemeanor. He came before a conduct officer, and he received an educational sanction. He was required to write a reflection paper, and in the paper he said he should have walked away. He also said, quote, I know I would get in serious trouble for physical assault, unquote. Based in part on the prior incident, the conduct board in this case expelled him. In doing so, the conduct board rejected Mr. Barber's self-defense claim. Essentially, the board simply could not believe that Mr. Barber could feel threatened by someone lying on the ground, unconscious and bleeding. Mr. Barber appealed to the appeals board, working with his advisor, Mr. Antonio Huffman. He raised numerous procedural issues. He argued that the conduct board disregarded Detective Patrick's testimony. He argued that the conduct board was biased against him as a Polynesian because they aggressively questioned him and said that he looked mad. He argued that the video of the incident, which shows him punching the other student on the ground, was prejudicial because it only showed a few seconds of that evening. He also contested 6 factual statements in the conduct board's decision, and he also claimed that the sanction was not appropriate. Importantly, he did not claim that there were questions he wanted asked of witnesses that were not asked during the conduct board hearing. This is because it did not happen. It was an issue manufactured by Mr. Graham once he filed the petition for judicial review. The appeals board affirmed the decision but reduced the sanction to suspension. And Mr. Graham filed his petition for judicial review and the motion to stay. Subsequently, the university decided that because Mr. Barber was so close to graduation, he would be allowed to do an independent study and complete his coursework in December. This was communicated to Mr. Barber a few weeks ago from the provost. To start with, the standard of review on a motion to stay is a heavy burden on the petitioner, and the burden is on the petitioner at all times. Because the conduct board found that Mr. Barber presented a risk to members of the community, he has to show that there was a likelihood of prevailing on the merits. In order to do that, he has to show not only error, but he has to show that the error caused him substantial prejudice. He has to show that he will suffer irreparable injury if the court doesn't grant immediate relief. He has to show that granting relief won't harm other parties and that he presents no serious threat to public safety. As I'll explain, he can't show any of these factors. I'd like to focus on the petitioner's claim first that WSU failed to ask certain questions during the conduct board hearing. Noted that the conduct board did not have the benefit of this court's decision in the Heredia case. That decision was filed on October 16th, and this case was heard on September 7th of 2016. But more importantly, this was a very different situation and requires a different result. First of all, Mr. Barber waived this issue by not raising it at the appeals board level. Until Mr. Graham was hired to file the petition, there was never any claim or suggestion by Mr. Barber or his advisor that the conduct board failed to ask all the questions Mr. Barber proposed. There is extensive case law. He needed to raise this issue before. This is based on sound policy. Failure to raise an issue denies the university the opportunity to address it and undermines the university's decision-making. There are very limited exceptions, none of which are applicable here. Mr. Barber's counsel first claims that the appeals board had no jurisdiction to hear the issue. This is false. The appeals board hears claims of procedural unfairness and hears claims of other natures regarding the proceeding. Unasked questions clearly fall into this procedural error category and the general unfairness category. Secondly, it's ironic that Mr. Graham would raise this issue given that he did raise the issue of unasked questions in the Heredia case before the appeals board, which is what allowed this court to address it on the petition for judicial review. He claims that it's a constitutional issue and it cannot be heard by the appeals board. This is also incorrect. It's a procedural issue, again, squarely within the purview of the appeals board. He claims that Mr. Barber could not have known about the unasked questions, but of course he would have known if the questions were unasked. He and his advisor heard the questions being asked, and they said there were no more questions that they needed to ask. None of the exceptions to waiver apply here. The issue was not. I'd like to note that Mr. Barber could have chosen to be advised by counsel during the proceeding, but he chose not to. He chose Mr. Huffman as his advisor. So more importantly, though, the issue of unasked questions, it wasn't raised by Mr. Barber or Mr. Huffman because it did not happen. The declaration of Antonio Huffman, Mr. Barber's advisor, says he, quote, does not recall the questions, but he thinks some were not asked. And he thinks the unasked questions all of these questions are asked and answered. And afterwards, Mr. Barber told Mr. Jussel that he, quote, had no more questions. In other words, each question was carefully read into the record and answered on the record, which he now has. Not only that, but the chair engaged in follow-up to further explore the questions asked by Mr. Barber. In one exchange, she says, reading Mr. Barber's questions, to the complainant, were you consuming any other substances that night besides alcohol? And the complainant says, caffeine. And the chair, on her own follow-up, says, I read in some report that you were snorting caffeine. How does that work? Coffee grounds? And the complainant says, oh, it's silly. It's just caffeine pills. It's a silly activity, but it was not an illicit substance. So the full exchange shows not only that the questions were asked, but that the conduct board chair engaged in her own follow-up to make sure that they were fully explored. The transcript is part of the agency record. This record does, in fact, contain all the questions. So we do not, as Mr. Graham has alleged, concede that all the questions were preserved. They were preserved in that fashion. Finally, even if the court decides to address the issue and thinks that it's possible that there were unasked questions, Mr. Barber must show that failure to ask the questions caused him substantial prejudice. He cannot do this. The two areas, again, were where the complainant's alleged substance abuse and also Mr. Barber's claim of self-defense. The complainant's prior actions that night, including any alleged substance abuse, were immaterial to the conduct board's decision because Mr. Barber testified that he did not see who pushed him and he did not see who he was punching until the person was on the ground and after the second punch. The complainant's prior behavior, therefore, had no bearing on the conduct board's decision. Also, it's clear that from the conduct board's letter that the reason they rejected Mr. Barber's self-defense claim is because of the punch after the complainant was on the ground. This is demonstrated by the letter in which they say, quote, certainly after he was on the ground and unconscious, he was no threat to you, but you struck him again. This This is based on Mr. Barber's own testimony during the conduct board hearing. Mr. Barber said, quote, "Yeah, he fell and then I punched him again," unquote. And the chair said, "So you punched him when he was down on the ground?" This is in the transcript, page 31. On page 39, she asked him again. She says, "But once you struck him, once again, you struck him twice, correct? One hit put him on the ground." Mr. Barber says, "That's correct." The chair says, "And then you hit him again when he was already on the ground?" Mr. Barber says, "Yes, ma'am." And she's clearly struggling with this. She says, "And did you still feel like you were in danger when he was on the ground?" Mr. Barber says, "Yes, ma'am." Again, struggling with the idea that a person could feel threatened while the other person is on the ground, apparently unconscious. These are the undisputed facts and the basis for the decision. Whether the complainant was using illicit drugs, whether Mr. Barber felt threatened initially when pushed by an unknown person, those were not material facts to the decision. Thus, he cannot show that any of the alleged errors caused prejudice, and he cannot show a like. I'd like to address the issue of bias, if I may, briefly. Mr. Barber claims that the conduct. He points to the chair's statement that it's probably not the first time you've been in an altercation. That's on page 35 of the transcript. The board chair was fully aware of other altercations, including the one in the prior conduct record. Number two, she goes on to clarify, quote, "I mean, you get hit all the time playing football." And he says, "Yes, ma'am." So in terms of all could feel threatened simply by being pushed. It doesn't in any way show racial or ethnic bias. It shows that she knows he's a football player with the conduct history. Mr. Barber also points to a second comment that she looked mad in the video and not scared, and says that that's based on the fact that he's Polynesian. But again, that's how it looks when you're punching somebody who's lying on the ground unconscious. It's very difficult to see how somebody could be scared. Scared is not what comes to mind. There's a third comment, and Mr. Barber claims that the chair said shuffling rooms, which is something that they do so that the parties don't have to directly interact when they're questioning each other. Mr. Jussel asked the complainant to wait on his testimony. Barber gets set. We're going to have to move them back down. And the chair says, "Put him in a holding pattern," and the other board member says, "I guess it's better than a holding cell." And the chair says, "Holding." He belonged in prison or a holding cell. It doesn't show bias. Statements have no bearing on the decision, which again was based on undisputed facts. So in conclusion, the basic facts are undisputed. Mr. Barber punched an unconscious student lying on the ground, left him bleeding with a concussion, could have caused permanent. Barber's claims of self-defense simply are not credible under these circumstances. He had a prior history of threatening to beat the quote shit out of a police officer. They say there's no safety issue, but that defies logic. Is an emergency action. It's a very high threshold, very hard to meet. There must be a show of imminent harm. So perhaps here there was not an imminent threat, but certainly his conduct warrants removing him from the university community. Mr. Barber can't meet his burden of showing a likelihood of prevailing on the merits. He can't show irreparable harm. He'll miss a few football games, but he will graduate on time. I'd just like to add that universities across the country continually are criticized for failing to hold student athletes, particularly football players, accountable when they harm other students. Here, the university did the right thing, and they did it the right way. Therefore, we request that the court deny the motion to stay.
Mr. Barber and I feel that the facts that the opposing counsel outlines really aren't even what the alleged victim claimed in this incident. You know, it sounds like if the Attorney General were on the board, she would perhaps have read it differently and imposed a very grave sanction. But the board heard a disciplinary reflection paper, and this is just something for you to be suspended for 1 year. And aside from the interim suspension, I mean, if he were such a grave danger, why wouldn't they have trespassed him from the school pending, during his suspension? We've seen that before, time and time again. But the AG argues, well, there's this danger that warrants removing him from the university community. They have not removed him from the university community. He can go to the library, he can go to the Cub. If he's invited, he can go to a dorm. He can walk around on College Hill. There's no proximity requirement to stay away from the university. So I think that this is disingenuous for this to be suggested now. And they wave these facts in this light that even their own client didn't view it like that. That he somehow punched a person when he was unconscious on the ground. That's completely false. So another thing about it is the opposing counsel sort of like reads this transcript and kind of, I wouldn't say acts it out, but kind of gives some life to it. But if you listen to it, it's a lot different. Justify the fact that this fair and impartial decision maker was whispering about Mr. Barber behind his back, joking about the holding cell. You can barely hear it, but it's not as the Attorney General would characterize or as this transcript. And so I would ask the court to listen to that. And also when you listen to it, you can hear Dr. McIntyre pausing to paraphrase those questions. Heredia decision. But in the Heredia case, the court in May imposed a stay due to the fact that the court in May allowed an accused rapist to stay and allowed him back into school because of this grave procedural error. And yet the school 2 months later, 3 months, 4 months later, is still not preserving questions. I wrote in my declaration, I had excerpts from a case in 2014 where I complained that questions were being thrown away. It's clear the questions are always paraphrased. You can tell when someone's reading words that aren't theirs. You can tell when something's phrased by a football coach or a student as opposed to a PhD. Those were Dr. McIntyre's, Mr. Barber's, or Mr. Huffman's questions. So I think that that's really problematic. And the school, obviously takes this idea of the fact that students have to follow the rules. Well, the school has to follow the rules. And what sort of example do they set when they can't even follow their own rules, even after the court has sided against them on that ground? The Attorney General raises this public pressure on universities, to hold student ethics accountable. We want you to treat them just like any person, like any student, any freshman, like Mr. Heredia, or all the other people who have been expelled or disciplined with procedural errors from the school. If this is, something where the school's in a public spotlight, it's unfortunate that they would, make this mistake again and again. But the rules weren't followed, and accordingly, we would ask that the support for back in school until that this matter can be fully heard. Thank you.
All right, well, obviously, it's an important case, it's important to Barber, it's important to the university, and given the nature of the situation, I think it's fair to say it's important to all of the community. There's a lot of people concerned about this case, and sort of goes both ways. Agency action, specifically the university contact or university appeal here. Biggest sanctions were imposed against them, originally, and that's a suspension, which has the opportunity to graduate in support of the argument here in irreparable injury, court that was demonstrated in application for declaration, effective, specifically, related to professional football player here, and the other side, has the university concerned with community here. I want to stress that arguments concerning bias, favoritism towards football players, or prejudice against football players, and what I have done as far in this case, I have motivated. I also want to stress that what the court determined today is whether a stay should issue for the court can hear things in this case. Give everyone an opportunity to fully review the issue, give the court an opportunity to review the record in the case here, and to give this case detailed probability of consideration. That's the question for the court today. The appeal here, the court ultimately determined, point out, my authority here is limited. Fully Superior Court, review agency actions, whether it's the Department of Licensing or university, is governed by the Licensing and Administrative Procedures Act. The court is required to follow that law. That law limits, very substantially limits the court's authority on review. Significantly, and I think very significantly, given what is understood in this case, the court's review is limited to the record of the agency proceeding. Basically, review is limited to my reviewing that record, or in the Superior Court say, reviewing the record of the agency, and essentially making a determination whether an error of law was committed by the agency. The agency heard evidence, there was a hearing, and based on that hearing, factual findings were made, and a decision was made. It is clear the court provided information things you have to do, but just that legal assault is a self-defense. I'm for the findings on the evidence, and I need to stress, as I always stress, findings that board made for finding on this court. This court, on the legal review, does not have the authority to substitute my findings for the court's findings. No different from when I, as a judge or evidence, make practical findings for the evidence, and get sent to the Court of Appeal, the Supreme Court. A new trial, a new court does not have the right to make their own decisions, own findings as far as whether there will be witnesses and what evidence is important, what evidence is not. This review, this court, administrative review is bound to follow or to accept the findings, whether I agree with those findings or not to substitute my judgment as to practical findings for those of the board which saw witnesses, some witnesses were alive or widely bodies, and their demeanor in the decision. The factual findings is limited to determining whether there is substantial evidence in the record to support the factual findings that the agency made. It would be a very good issue. There were facts that were presented that would support all support self-defense. Very, very perfect. That's all that self-defense could apply. The issues that have been raised here are really narrow in scope. The issues that have been raised are whether the agency failed to follow their own prescribed rules, which covers their fact that the board did not totally preserve the record on appeal. As stated, on appeal, the limited authority this court has is to make the based upon the record. That is treated here as a portion of the record was not preserved, which was destroyed. And the significance of that argument is the position that Mr. Martin is taking here, that the board failed to ask relevant what the record was questions to be submitted. Those are the two issues that really have merit, and the court is I've heard numerous administrative appeals over the years, but the Whitman Department of Retirement System, labor industry, they use the whole board, and I've heard a lot of appeals, didn't like the process with the agency. And candidly, numerous times after reviewing the records, not just in student contact cases, but other administrative cases, that I've personally disagreed with the factual findings of the nature of the agency. And there have been times that have been critical to times in my own mind internally. But sometimes I couldn't keep my mouth shut, and externally I have expressed my criticism of procedures that were followed, and we've been asking for student conduct in those cases. But again, it is not my job to determine the facts. It's the board's job. It's the part of the Whitman's job, the administrative field here. We're part of the law. Student conduct procedures, I would strike here. My opinion, for a full suspension is involved. That's what we're doing here. I've heard several of these over the years, and I've heard many issues raised as to the constitutionality of WSU procedures, and I've heard numerous arguments as to the legal validity of the procedures that are followed. And that's an area I know on a couple of occasions. Has expressed my personal opinion, personal concern about procedures and fairness of some procedures. I probably should have done my own stuff, but that's just difficult to do. But as a judge, not to decide cases on my personal opinion, I decide cases based on the law, and we have the body of law, small body here in Washington, right out of Whitman County, with the conduct board, support the constitutionality follows the conduct process. And despite the personal opinion, I'm now going to build the constitution and the reality of whether it's society. And I believe for the time we see the one of those cases before the bill and the public court. We need to see what happens, but I thought I was right in the law, even though I didn't agree with the law, made a decision to do that with the court. It's important for courts to be consistent. So insofar as Mr. Barber here raises challenge to the constitutionality of WSU student conduct procedures, has been persuaded, and plan today is consistent with the findings that the city have made previously, and certainly not going to find that he's likely to prevail in this appeal based on the constitutional grounds. At the time the case comes up for final hearing here in the field, we will have public decisions for my rule or overrule that rule. I reviewed the Barber's petition to review, and quite a bit of reason for it. And for state here, I don't really feel he's bringing the constitutional challenge. I think the lesson here is that he didn't follow. And that's the basis of my bringing it, and I think it's going to make it WSU has adopted volunteer to know while a student being accused of conduct violation to submit justice against the usual questions or witness to the board chair and use that there be discretion of the board chair to determine whether that question should be acted. And you will be the discretion of the board chair to determine the questions are asked and proof, ascertain whether witnesses are showing the proof. This is a long recognized principle in the system. That principle has been adopted by the students at conduct board of WSU follow. Also, we have a state law that requires administrative agencies to maintain a record for all documents that considered by the presiding officer. That's important because you have a right to review the agency's decision, which hopefully is here. As I said about 5 times here, that review is based on the record. Because the record is written, it is difficult, if not impossible, to perform the job for the university agency job. And this court, personally, recently interpreted the statute that requires agencies to maintain their record. My interpretation of that statute is that it requires the conduct board to retain the written questions suggested by the student. Important because the court has to review whether there are law occurs. It has to determine whether the decision that the presiding officer made, including the security of evidence, was legally proper. Yes, the WSU rule of that sample discretion in the officer to decide whether to ask questions. This court has tested all kinds of decisions, particularly with discretion. Discretion and the authority to exercise discretion. Under the law, however, isn't an absolute right the judge and hearing officer has. It has to be based on reason, and discretion cannot be abused. It isn't the judge or the hearing officer, he or she has been given discretion to do anything he or she wants. It has to be based on sound reason. And anytime the judge or hearing officer exercises discretion at the trial level, two things are dispute. The best dispute is whether all of Mr. Barber's questions were asked. There's also perhaps a dispute as to what his questions were. An argument, well, he didn't observe those questions, doesn't remember what the questions were. And also dispute as to whether the questions were significant, whether they mattered. Barber's expected to follow rules and go to school. Conduct of work is required to follow the rules as well. So the rule is observe the record. And I can have an affidavit from the Barber side saying, Mary Diagnosis didn't ask some of the questions. And I have from the other side, yes he did, or yes he did. He asked all of the questions. We have a dispute here. But this dispute would be very easy for me to determine. It would be very easy to resolve. He's telling the truth. Counsel here, or the advisor, or Mr. Barber, it would be very easy to determine by reviewing the transcript as to what was asked and reviewing the questions that were asked. Why can't that be done? Questions. And I do find it interesting that, and I just recall, the decision I made in the previous case on this exact point was related to the question and the importance of observing questions. That decision was rendered after the hearing in Mr. Barber's case here, but find from Mr. Graham's affidavit that he filed, he had raised that issue to the board before, this very board, and he did have a hearing in the case that he had previous to the hearing of this case, where the court granted a stay based on the decision of Graham stay on my likelihood that the defendant would prevail in that case on the appeal. So at the time, Mr. Barber's hearing here, this court's legal interpretation of the problem of throwing the question, as well as knowing to the content of it. What we have here is a issue that's different than the other case. Surface points. We have here he said, that was the situation. It may not be exactly correct. But we avoid these problems. The board would avoid these problems. As it's done with the law required. That's correct. We also have, clear from what's been submitted, as to the decision that the board made, he said, like most of the witnesses were male. I don't know that. I haven't reviewed the record. And a lot of the witnesses, they said, it sounds like, from what I read, was presented in hearsay facts in front of the police officers that testified. Police officers designated as crimes candidates, two sides of the story, assault. No question, there were two roles in Mr. Barber. He's not disputing that. The position is he did that himself, and to protect himself, which is disturbing. There was, and I've read what has been submitted, I feel very proper inquiries from the video. I haven't had a chance to do the video before it did, but the point is there was pretty penetrating what I'll call almost question the need to cross-examine the pioneering officer, Mr. Barber, for the purpose of trying to ascertain truth. And we have the position of Mr. Barber here. I want to challenge the complainant's credibility. I want to challenge it on the basis of how did you really remember that maybe he was under the influence of something and he took the position that it was. And you want to challenge the issue of self-defense that he was assaulted. And I want to ask you to answer the judge's rule how to ask the complainant those questions according to that answer cross-examination. And if questions are not asked, you guys are right on the field for the court to determine whether there will be abuse of discretion by not asking those questions. Mr. Barber claims he was deprived of his cross-examination right and difficult in the court because the university didn't follow the rules for the court to determine that issue. It's also difficult when the court doesn't know what the questions were to determine, well, would it appeal on the basis of unfairness and bias in very general terms and in some specific terms. You know that you didn't specifically say, I asked them the questions, you were taught the questions, and they weren't asked. The board has said further to follow their own rules, preserving the record. It's difficult for the court to determine what the questions were asked, whether they were material. The issue here is whether this is something that can be raised on first time. But I do know the rule, what they call it an informal adjudicated procedure, probably the brief adjudicated procedure. Rules of evidence don't apply. You can have a lawyer, you can have an advisor, these types of hearings. The advisors cannot actively participate. They can sit right, they can talk to the person who rules of evidence don't apply. Doesn't that mean you don't have to object to questions that are asked in order to usually that's just who wins the battle may or may not win the war. Not deciding today who is going to win the war. And deciding today to declare today, I feel very strong likelihood that Mr. Barber naive. I recognize that winning this war, and quite frankly, that's why I spent a certain amount of time in reviewing those things, considering the issue, winning the battle here may turn out to be win the war. Although I am aware that the cases where there's been saved, there's been students who graduated, ultimately lose the contestation, and lose their degree. That's an issue that I don't know, but I have to decide the case here today based upon the factors that were outlined earlier, and there's a likelihood that this is someone will prevail, by prevailing, probably result in the hearing of the conduct board and doing things correctly. And we know what would happen to the result of a second hearing. As we feel that there would be irreparable injury at this point, if the board were not to be able to stay for the matter to be fully heard, do not feel that there is a danger to the university community going to like to be based upon to me very concerning evidence of a prior problem. But this concerning it is concerning the conduct that has gone on for a significant period of time. And I believe in the same manner that I did last time I issued the stay, and when I issued the stay in addition that and the condition will be Mr. Barber is that no contact, no communication with the victim. I will work as well with the record reflects we disputed as to how much was alcohol involved, and in order to be not consume alcohol, not consume any unprescribed adulterated drugs, including marijuana, and that he not fit in any party functions, activities, where alcohol or drugs are being consumed. And I feel absolutely concerned about anything that is connected to the matter of the court. How about we have to review the order of detail we have that detail we would like to review resolve. And make sure that the administrator will be working on the scheduling order for the appeal. And good news and bad news, we'll be working on the scheduling order. And whether it's good news or bad news, but scheduling will be such, will be after my that's good news for everyone. Tom, I want to thank both of you for very thorough reading and presentations here. And we will be back. Thank you.
I have some proposed order here. I'll pass it to council in a moment.
I'll let you work on that. Whatever's in the future. If you come up with